Speaker for today's webinar, Professor Roger Halson, International Director and Professor of Law, University of Leeds, respected Director and Dean, Professor Dr. Purvi Pokhriyal, faculty members of Institute of Law, students, and dear participants. On behalf of Institute of Law, Nirma University, I welcome you all to this webinar on penalties, liquidated damages, and London buses. Before beginning this webinar, I would request everyone to please stay on mute. We will have session on the topic for around 45 minutes, and then we will have questions in last 15 minutes. You all are open to pose questions on the chat box. All these questions should be directed to me. With this, I will request Professor Dr. Purvi Pokhriyal, Dean and Director, Institute of Law, Nirma University, Ahmedabad, to give welcome address.
Thank you, Amit. Distinguished Professor, Professor Roger Halson, our dear friend and our global professor, Professor Stephen Barnes, my faculty colleague, Mr. Amit Kashyap, the other faculty colleagues, staff, and dear students. Please join me welcoming a great scholar of contract and commercial law, a renowned author and a distinguished professor, Professor Roger Halson from University of Leeds. Professor Halson is a renowned author when it comes to the books on contract and commercial law. Professor Halson has recently published a wonderful book on liquidated damages and penalty. And when it comes to citing by the US courts and the UK courts, this book is being tremendously cited, and we are great to have Mr. Professor Roger Halson. Professor Halson has also worked earlier with the University College London and also with Nottingham University. Professor Halson has been a great researcher and has been associated with the Center for Business Law and has written extensively on the issues of damages. Today, again, Professor Halson has taken a topic which is of wide interest to all of us, and that is pertaining to the liquidated damages. On behalf of the entire Nirma University team, on behalf of my students and faculties, we wholeheartedly welcome you, Professor Roger Halson, and looking forward to your lecture. Thank you.
Yeah, thank you, ma'am. So, ma'am has already introduced Professor Halson. He is a professor of contract and commercial law at University of Leeds, and presently he is also an international director and also has been head of School of Law. His very recent book, that is Liquidated Damages and Penalty Clauses, is one of the first monograph which is published in UK and US on this key commercial topic, and it has been referred by jurists, by lawyers. So we will recommend all of the students also to refer this. We are fortunate that last year I was reading his book, and now Professor Halson is here with us. His work is published in leading academic journals like Oxford Journal of Legal Studies, the Law Quarterly Review, Current Legal Problems, Lloyd's Maritime, Commercial Law Quarterly, and so on. He has written many books, co-authored 5 books on private law, and he has also contributed essays on contract law. With this introduction, I request Professor Halson to deliver his session on the topic.
Well, thank you very much for your very kind words. Thank you very much to your Dean for the kind words and also for the invitation to deliver this session. I'm very, very sorry I can't do so in person. I don't know, I would love to be there to see some of your sunshine. And I showed this to some people earlier, but if I move my computer, I think you can see the view from my window is that we have snow in the UK today. So snow has arrived, much to the delight of my daughter, but perhaps slightly to my annoyance. Anyway, it's lovely to have the opportunity to deliver this lecture. My name is Roger Halson from the University of Leeds. After your kind introductions, I don't need to say any more about myself. The only thing of a personal nature I did want to say at the outset was I wanted to offer an apology, really, for what my students and also my children tell me is my rather eccentric sense of humour. So I've exposed you to a little bit of that sense of humour to begin with in the title, Penalties, Liquidated Damages and London Buses, but I hope I'll be able to convince you of the relevance of that title. You might have heard a saying in the UK that you wait a long time for a bus and then two come along at the same time. And so indeed it was for contract lawyers interested in so-called penalty clauses. In the common law system, we know that we're dependent upon the accidents of litigation. We have to wait for a case with a particular subject to come along. And then as academics, we sit there and we hope that it will be appealed to our highest appeal courts and then reported. Well, until 2016, the leading case on so-called penalty clauses was a decision in 1915 in a case called Dunlop and New Garage. But in November 2015, 100 years later, lawyers in the UK, like myself, received an early Christmas present. And that was the form of our courts, our Supreme Court's judgment in a case called Cavendish Square Holdings against McDessie. Now, it's sometimes said that the very best Christmas presents come in the smallest of packages, but that wasn't true here, because you can imagine we normally have 5 justices sitting in our highest court, but on important cases we tend to throw a few more in, maybe in the hope that they then get the right answer. And we had 7 justices sitting in this particular case. And you have 7 justices sitting on a case in a key commercial area which has not been considered for almost a century. So we were never going to get a small package. And what we got was the longest judgment of our Supreme Court in that whole year. So it was a very thorough review. Now, I made a comment about London buses coming along in twos, and so it was here, because after all this time without a thorough re-examination of this topic, only a year and a half earlier than the UK decision, the highest court in Australia, the High Court, also reconsidered and reformulated the law on penalty clauses in Australia. Hence my comment about waiting a long time and 2 buses coming along together. So let me just take a minute just to describe what the subject matter of my topic is. And here I will ask you just to indulge that awful sense of humour of mine just for a little bit longer. This is the topic we're going to look at today. And I hope you can see that what it is a penalty clause. Okay, please forgive the humour. But you'll also see from the first slide something very personal to me that several of you will know already. And you may also be able to tell from my accent, but I am, of course, a Liverpool supporter. And indeed, it is Liverpool Football Club who are taking the penalty there. So this is the subject matter of the lecture. We're going to look at penalty clauses. Now, we sometimes contrast penalty clauses with the term liquidated damages. So let's just work out exactly what it is I'm going to talk about. Liquidated damages are damages that are assessed, damages for breach of contract, that are assessed by a clause in the contract which is breached. And we contrast liquidated damages with what we would term unliquidated damages, which are damages which are assessed by the court. A valid clause in a contract we will often call a valid liquidated damages clause. Sometimes we just use the phrase liquidated damages clause to refer to one of these clauses which is valid. And we contrast that with a clause in a contract which provides for a payment which the courts refuse to enforce, and usually we call them a penalty clause. And hence we get the phrase the penalty jurisdiction, by which we mean the power of the courts to not enforce a clause in a contract providing for the payment of a sum of money. Now, what is the effect of a penalty clause? This is the effect of a clause in the UK. Well, if the clause is held to be a penalty, it is unenforceable, and the claimant must seek unliquidated damages. Now, I understand from my researches on Indian law that there is a contrast here between our common law provision and the statutory effect of clauses controlled by Section 74 of the India Contracts Act. In the UK, if something is a penalty, it is unenforceable, and the person must seek unliquidated damages. If it is valid, the only consequence here is that the clause is enforceable to its full extent. So once it is valid, you recover that full amount under the clause, whatever the extent of the claimant's loss. And there's an inevitability here, really, isn't there, which is often unrecognised, which is that the damages you recover under a valid liquidated damages clause will almost inevitably be wrong, because we all have a limited ability to predict the future. If any of us could predict the future with certainty, we'd be very rich, wouldn't we? We'd be able to gamble and always win. We'd be able to buy stocks and shares that go up. But we cannot predict the future. So at the time parties contract, when they at that point have to estimate in their liquidated damages clause what would be their losses in the future if the contract was breached, really, given that we cannot predict the future, that will inevitably be an overestimation or an underestimation, but it will be the best guess they have at the time. Now, there are two key questions here, and I think we often mistakenly concentrate only on the second question when we're discussing penalty clauses, because there are two key questions to be asked. The first question is whether the clause is subject to the penalty jurisdiction. And different words are used here. Our courts have recently asked the question, is the penalty jurisdiction engaged? Sometimes we say, is it triggered? What we are asking then is the clause subject to the penalty jurisdiction? Do we have to ask the question whether it is enforceable? And if yes, it is subject to the jurisdiction, we then have to apply a test to see if it is enforceable. So there are two questions you have to ask, and these are very important because when you are drafting contracts, you will often try to draft the clauses in a way that avoids the application of the penalty jurisdiction. So we never have to apply the test for a penalty because it the way you have constructed the clause falls outside that jurisdiction. Just a couple of broader comments at the beginning, just to say how unusual and odd this jurisdiction is. Because I think you can see instantly that there's a conflict between saying we will set aside some clauses and not give effect to them because they are unenforceable penalties, and the basic principle of freedom of contract. In our common law jurisdictions, we say that our starting point for the law of contract is that parties are free to contract on whatever terms they wish. And that is the starting point. And of course, the penalty jurisdiction is a clear qualification or derogation from that general principle, because it is restraining the ability of parties to contract on whatever terms they want. Now, the longest chapter for me in the book that I completed on the for OUP, a little bit of free advertising there. The longest and most demanding chapter I wrote on in that book was an attempt to explain why we have this penalty jurisdiction. And I can only give a flavour of that here. But here are three different rationales that have been given, explanations as to why we might have such a rule. The first here is the rationale: it prevents unfair advantage taking. We have this rule to stop one party opportunistically taking advantage of another. But it can't provide us with a complete explanation, because the tests we apply to determine whether or not the clause is enforceable do not require any direct evidence of advantage taking. It was said in an old case by Lord Wright, a millionaire may enter a contract in which he is to pay liquidated damages, or a poor man may enter into a similar contract with a millionaire. But in each case, the question is exactly the same. The test that's applied is applied irrespective of which party might be taking advantage of the other. Now, that is very different to the way the law was developed in Canada, where the idea of unconscionability of advantage taking is very much key to the way they have formed their penalty jurisdiction. The second possible explanation for having this doctrine has been a sort of economic argument that what it does is it reduces transaction costs. Now, what do we mean here? Well, I think you have to look at the position of the parties in two different points of time. The position of the parties before there is a breach and the position of the parties after a breach. Now, if you look at the pre-breach position, if you think and look through the eyes of the promisor, that's the person who undertakes to pay this sum of money if the contract is breached, you could say that the advantage to the promisor is that they know what the consequences of their breach of contract will be. They know that if they breach the contract, they will have to pay this sum of money. And economists say that that encourages the concept of efficient breach. So that if I am selling you something and I know I have to pay a sum of money in the event that I don't supply you with that good, if someone else offers me a sum of money for that good, and I know the profit on the second sale will be sufficient to pay the liquidated damages I owe you if I breach the contract with you, then I may undertake an efficient breach in that you are fully recompensed through the liquidated damages, and the party who values the commodity, excuse me, most highly gets the commodity. So economists would say that these clauses can facilitate efficient breach. From the perspective of the promisee, you could say that the liquidated damages clause is advantageous because they know exactly what compensation they will receive in the event that they do not get the promised performance. And if the compensation is not sufficient to fully recompense them for their losses, then they can go out and obtain further insurance with a third party through an insurance policy for that shortfall. So they are the advantages identified pre-breach from this jurisdiction. Post-breach, it's often said that these clauses save legal costs. By having a clause whereby the parties have themselves calculated damages, it saves the public purse because the court does not itself then have to assess these legal damages. Well, my suggestion is that these explanations are probably understate the real costs. If you are contracting and you are confronted with a clause which says that if you fail to supply a good or service, you will be required to pay a sum of money. As a good contractor, your response would be to draft another clause stipulating the circumstances in which you will not be responsible for the failure to supply. We typically call such a clause a force majeure clause, because if you are prevented by circumstances beyond your control from supplying a good, then you will not want to be taking upon that responsibility. So my suggestion here is that I think there's an error in this rationale, because there are considerable costs to the parties the moment somebody wants to put in one of these clauses, because the other party will then have to spend a lot of time drafting and then negotiating a force majeure clause. In the common law, the most convincing explanation for anything is often history. It might not be very forceful, but we often come to the conclusion that the best explanation we have for some feature of the law is that we've always had it. And I think that is probably true in this case, that these penalty clauses have a very, very long history. I'm limited as to time, but probably the most famous penalty clause of all, certainly the most famous in literature, is probably the penalty clause in William Shakespeare's Merchant of Venice, with which you might be familiar, where Shylock proposes that a pound of the merchant Antonio's flesh should be forfeit if he is unable to repay a loan which Shylock, the money lender, advanced to him. When Bassanio, for whom the loan was taken out, asks his friend not to enter the bond, Bassanio says, "You shall not seal such a bond for me." That's my best Shakespearean voice. Antonio brushes away his friend's worries. "Why, fear not, man, I shall not forfeit it." And when Antonio is unable to repay the sum, he's saved from having a pound of his flesh cut out by the advocate Portia, who comes to his rescue and says to Shylock, yes, a pound of that merchant's flesh is thine, but this bond does not give thee one jot of blood. And of course, if Shylock shed a jot of blood, he would forfeit all his goods. And so Antonio is saved. Both Australian High Court in the Andrews case and the UK Supreme Court in the Cavendish case both agreed that history was very important. But history alone cannot explain the correct doctrine to have here. And that is proved by those two courts, because the two courts, as we'll see in a minute, came to very opposite conclusions about the proper scope of the penalty jurisdiction. And they both justified it by reference to their own historical analyses. So this slide has been, in a sense, a slight disappointment, because I've only been able to give you a flavour of the reasons that have been advanced for this, to justify this jurisdiction. And the conclusion in my book is that there isn't a single explanation that convincingly tells us why we have this jurisdiction. My suggestion is that the explanation and justification is multifactorial, in that there is some element of truth on explanation in several different rationales. The old law in the UK. The old law in the UK, which was established in Dunlop and New Garage, the facts of which are there, which I won't go through. And in Dunlop and New Garage, the House of Lords held that the payment was not a penalty. They did that by applying the twofold test. The first part of the test was asking whether the penalty jurisdiction applied. Did it provide for the sum to be paid on breach of contract? It did, and it then applied a test. And I'm just going to take a second to explain to you the importance of this breach requirement. And I've used an example here, which students may be able to relate to. Let us assume that to avoid late payment, the university is amending all its accommodation agreements with students. And it proposes two drafts. Under draft one, students are required to pay £1,000 a term, payable before the first day of term. And any student who doesn't pay is in breach of contract and has to pay liquidated damages of £500. If that was the arrangement, then the £500 would be subject to the penalty jurisdiction. Clause 2 provides for a sum of money to be paid on breach of contract, and so we have to ask, is that enforceable according to whatever test is in force at the time? Consider draft 2. If the university chose instead to phrase its contract in this way, and I have to plead guilty here to giving a university advice along these lines once, probably to the detriment of my own students. But let's suppose it said the cost of accommodation is either £1,000 payable on the first day of term or £1,500 payable after the first day of term. Can you see two things? Number one, the effect upon the student is the same in both cases. Under draft 1 or draft 2, their accommodation cost them £1,000 if paid before the first day. It cost them £1,500 if paid after. However, in draft 2, the failure to pay £1,000 on the first day of term is not a breach of contract. And that is key, because the penalty jurisdiction is not engaged in draft 2. There is no trigger. Draft 2 does not provide for the sum of money to be paid on breach of contract. It simply provides for 2 alternative considerations. You can have the accommodation for £1,000 paid before or £1,500 after. And if you want to disguise what you're doing even more, you could have a draft 3 that says the cost of accommodation is £1,500 per term. However, if you pay before the first day of term, you will be entitled to a discount of £500. And that draft would also not engage the penalty jurisdiction. Now, why I've emphasized this is the big way in which parties drafting contracts avoid the penalty jurisdiction. They make the event upon which the sum is payable something other than a breach of contract. Now, in Dunlop, there was a breach of contract, and the test which was applied was this. We were given this definition by Lord Dunedin, that the essence of a liquidated damages clause is a genuine covenanted pre-estimate of loss. What is a penalty? They don't expressly say it, but it's the converse of this. So if the clause provides for the payment of a sum in excess of a genuine covenanted pre-estimate of loss, it's a penalty. So a penalty is a clause where damages are payable that are more than a genuine pre-estimate of loss. That was what we had for 100 years, right up until this case of Cavendish and McDessie. 2 appeals were joined together in this case when it went to the Supreme Court. One involving one of the highest value contracts you can imagine, and the other a very low value contract. In the Cavendish appeal, the issue was the enforceability of 2 clauses in a very substantial commercial contract where the consideration payable, if those clauses were upheld, would be reduced by over $40 million US. The other case involved the enforceability of an £85 charge for overstaying at a car park. The clause said, you can stay for this long. If you stay longer, you must pay an £85 extra charge. Both of those clauses, were upheld by our Supreme Court. But what interests us more is the grounds on which they do it. Now, the first thing they did was they refused to abolish the penalty jurisdiction. Now, I could not have been more relieved when this happened, because I had a half-completed manuscript for my book on penalty clauses, and I was aware that the argument was being put to our Supreme Court, just abolish this doctrine. Just let parties include in their clauses whatever they want, make no special provision for penalty clauses. Now, I would have had a very wasted manuscript had they abolished it, so I was very grateful. When my book was launched in London, I was very pleased that 2 members of our Supreme Court came along to the book launch. So I was able to thank them personally for saving my book by rejecting the invitation to abolish the penalty rule. But what they did do is they said there must be a strong initial presumption of enforceability in any situation where parties are legally advised and have equal bargaining power. They said that the Dunlop test will no longer apply generally, and that instead, the final point there, very important, and I understand that this is not completely settled in India, but is probably the case, that the penalty jurisdiction will continue to only apply where there is a breach of contract. So it does not apply to non-breach events. That was the huge difference between the UK and Australia, because the High Court of Australia said that the penalty jurisdiction will apply to non-breach events as well. So that is what our Supreme Court did. And this is the new test that they said should apply whenever a clause is subject to the penalty jurisdiction. So this is the magic passage. The test is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. Quite a mouthful there. So let's reduce that. My first two bullet points here are really the summary. If you want to enforce a clause now, you have to show two things. First, that you have a legitimate interest in enforcing it. And secondly, that the amount in the clause that you are stipulating is proportionate to the protection of that legitimate interest. So the test isn't about genuine pre-estimates of loss anymore. It's about, do you have a legitimate interest to protect? And if you do, is the protection proportionate to it? And the new test, like the old, is applied at the moment of contracting, not the moment of breach. Okay. I told you that the clauses were upheld, i.e. enforced, and in Cavendish, in the contract that involved the sale of a huge business, the clause which said that if the seller of the business competes in any way with the business that he has sold, he has to pay a penalty clause, was said to be, was upheld because it was said that the purchaser of a business has a legitimate interest in protecting the goodwill of the business that he has paid a large sum of money for. And in the parking eye appeal, it was said that the person running the car park, which was a car park adjacent to a large retail park, has a legitimate interest in imposing this charge if you overstay your permitted 2 hours, because they have a legitimate interest in wanting a fast turnover of cars to get as many people through the shops in their centre as possible. So I'm just going to, I've got about 5 more minutes, I might take 6 or 7 just to finish. I've told you so far how the law has changed in the UK. And I'm going to move on now to say how that has been received in other Commonwealth countries. So this is my colour coding for the old law in the UK and the new law. The thing in red is our Dunlop case. Penalty jurisdiction only applies when there's a breach, and the test is whether you provide for a sum greater than a genuine pre-estimate of loss. The new law is the same in regard to number 1, because in Cavendish they reaffirmed that the penalty jurisdiction only applies to breach. But we changed the test because a valid liquidated damages clause is about the proportional protection of a legitimate interest. So there my colour coding. And here is the law in Australia. As you can see, point 1 is in black because it is different to either what was said in Cavendish or what was said in Dunlop, because in Australia, in the case of Andrews, they extended the penalty jurisdiction to non-breach events. And we might, in questions, if anyone asks, I could explain a little bit more as to why they did that. But what they did was they agreed that if the penalty jurisdiction applies, in Australia, they agreed that the test would be the same as that, substantially the same as that in the UK, that it will be upheld if it is a proportional protection of a legitimate interest. But they differed in the final because it seems that in Australia, even if the clause is invalid, then it can still be enforced partially. And New Zealand followed the UK. They followed the Cavendish jurisdiction, hence the 2 greens. They both agreed that it should only apply on breach, and they also agreed that the test would be the same as that in Cavendish. The recent case in which that was established by the New Zealand Court of Appeal is there, and I was very flattered by the fact that they relied on my book in that case. Singapore partially agreed with the approach in the UK in that they agreed that the penalty jurisdiction will only apply if there's been a breach. But you can see by the red that they decided to stick with the old test in the UK, the Dunlop test. Again, this case was only reported, it was a lovely opportunity having this lecture. It was only reported about 4 or 5 weeks ago. I'm just writing a note on the case actually at the moment for the Law Quarterly Review, which you might want to look out for. But again, I was pleased that the Court of Appeal of Singapore relied on my book in that case. So, well, looks like I'm almost on time. Let's have a little bit of a concluding assessment. Well, I was at a lecture some years ago at UCL, University College London, where I used to teach, when Victor Goldberg said, visiting American law and economics scholar, said, he confessed to being surprised and disappointed in learning that the English treatment of penalty clauses is no better than the American. Now, I do look at the American treatment of clauses in my book, but I haven't had, it doesn't map very easily onto the review in the Cavendish case, so I haven't included that in this lecture. But my view when this was said was that the UK law was probably in a better state than the US law actually. And after Cavendish, I'm even more convinced. I think the UK law is in a good state. The thing I think is of value is that the rationale, the justification for the control forms part of the test, that you have to identify the legitimate interest you are seeking to protect. And I think that the very explanation and the justification for the rule forms a part of the test you're applying. And I think in terms of openness, transparency, there's a value to that. Now, will we have to wait another 100 years for the next case on this subject? Well, there are few certainties in life, but one will be that if we have to wait another 100 years, I won't be here at that point in time. Perhaps with advances in modern science, perhaps some of the undergraduates listening to this might hope to be here in another 100 years, but perhaps not. Maybe modern science won't advance that far. What I do hope that you might take away from this lecture as my concluding comment really is that I hope you might take away, when you're looking at the application of this area of law in relation either to the Indian Contracts Act section 74 or any other provision on liquidated damages, I hope you might take away the discussions we've had today and reflect on them to inform how your view of how the law should be. And the couple of factors I want to emphasize are the one I have already about the explicitness of tying the justification for a legal rule into the form of that legal rule, so that we say exactly what it is we are doing. And the second thing I think I'd like you to think about is the importance of certainty, because underscoring a lot of what I've said here is the importance of certainty. The Singapore Court of Appeal emphasized many times that they thought certainty was a preeminent feature and requirement of commercial law. Recourse to the court's costly litigation is reduced to the extent that the law is certain and predictable. And one of the huge justifications for not following the Australian rule and saying that non-breach events come within the penalty jurisdiction is that the danger is you make too much of a contract, too many clauses in a contract become potentially reviewable and subject to this doctrine. And one thing that has emerged as a divergence between UK law and Australian law in the last 20, 30 years has been the extent to which Australian law is prepared to accept a higher level of uncertainty, ostensibly to do better justice between the parties, than UK law, which perhaps is more commercially based, which puts a higher value on certainty. So I've overrun by 4 minutes, I think, by my watch. So thank you very much. That's the end of my presentation.
Thank you, Professor Halson.
So much.
My dear students and faculty members, if you have any question, you may post it to me or you may ask. Sir, I have one question with respect to enforcement of liquidated damages. What exactly is the trend that you have observed in UK courts for its enforcement? Is it pro or is it against the implementation?
Well, thank you for that. That's a very good question. I actually employed one of my students to do a little bit of empirical work when I was doing my book. And I got them to look at all the reported cases under the old law, because that was all I had till then, as to whether or not the result of the case was the enforcement or the non-enforcement of a clause. And the trend, even under the old law, was that cases, more and more clauses were being enforced. So the movement was towards enforcement. Now, this test, if you like, I think you're best thinking of the new test as imposing a lower threshold of enforceability. So that movement towards enforceability, I think, has gained more momentum. So more and more of these clauses are being enforced, or put the other way, it is harder to strike down such a clause. And I think that is the trend. If you like, it's a trend towards freedom of contract. If these parties are, if I put it in a strange way, especially when they are big commercial parties, if they are big enough and ugly enough with wonderful lawyers acting for them to look after their own legal interests, if they stumble into a clause that is very onerous to them, then that is their fault. And I think that might be the thinking of the court, although of course they would never put it in those terms.
Yeah, Professor, I think the teachers who teach contract law also will agree that liquidated damages clauses are more sensitive for project finance industry and construction industry basically. And during COVID-19, this could have been a major problem. So how do you think that this has been addressed by UK government?
Well, I don't think we have addressed it in that sense. I think the way in which, when we're talking about the effect on contracts of COVID, liquidated damages are, as it were, the second part of that equation, aren't they? The thing that the focus should be upon is upon the exculpatory clauses that come before the liquidated damages. You know, the focus, if we think the law should adapt to these unexpected circumstances, then it is the law relating to force majeure and frustration that should be doing the job. We shouldn't be having to mess around with the remedy, the remedial law, in order to make right defects in the substantive law as to whether or not the contract remains valid. So I think the focus has to be upon the law of frustration and the interpretation of force majeure clauses. But you're certainly right that there has been, and it plays out for the reason I've said, to a greater extent, if you like, in the UK, because when you have that commitment to certainty, then there is always going to be a tension between that higher level commitment to certainty and having a law of contract that is adaptable to changing circumstances. And I mean, you're probably aware, I mean, I'm anticipating some considerable changes in the UK because in two different, if I was being, I can't be too rude, can I? I know I can't be too rude. Our Supreme Court, I think the contractual expertise in our Supreme Court is greatly improved in recent years. For the first time, an academic a year ago was appointed to our Supreme Court. So Professor Andrew Burrows, who writes a book on the law of remedies, has been appointed to the Supreme Court. We also have a judge called Leggett, who was appointed from the Court of Appeal, who has a Harvard LLM at which he studied good faith in contracts, and has, in his own judgments in the Court of Appeal and also as a High Court judge, very much pushed the idea of good faith. So, I mean, these are two small factors, but I'm anticipating that we will get a more nuanced level of judgment from our Supreme Court, which might introduce more flexible contract principles, which might be more receptive to doctrines of good faith, which might curtail a little the huge emphasis on certainty. And that might be accelerated a little bit by the demonstration that we need to adapt to unanticipated circumstances, which the COVID episode has shown us all. So I'm sorry, that was a very long-winded answer to your question, but I think we could expect some changes.
Sure, sir. And there is one more question from our faculty, Ms. Surekha. What can India learn from UK and Australian penalty laws? As it's a very long question. Penalty laws as in prosecution for our own development of laws. What can Indian law learn from UK with respect to this?
Yeah, I don't think I wouldn't be ever so presumptive as to say there's a lesson in the sense that we think this is right, so you should think that is right. I think the prior question is, to what extent do you think it's appropriate to promote contractual certainty over other values? And your answer to that will take you down a certain route. Now, I will be fascinated if any of your faculty or students could direct me to any discussions in your courts on liquidated damages. Obviously, I did my own researches, and I cannot be as up to date as in researching, or as expert in researching Indian law as your faculty can. So please do direct me. But I understood from what I read that it was probably the case that Section 74 only applied to breaches of contract, clauses that provided for a sum to be paid for breach of contract. But what I read was that that had not been definitively decided. Now, I would suggest that if my reading was correct, is something that can only be resolved by deciding how certain you want your law to be. Because the moment we introduce uncertainty, and the moment the sums in these cases get near the sums in Cavendish, 44 million US dollars, then there's one hell of an incentive to engage in protracted litigation in order to try to get out of having to pay 44 million US. So we really need to know whether or not these clauses apply to non-breach events. And the investment in the UK was huge. I didn't mention, but some of the biggest litigation we had in the UK recently was in relation, in 2009, in relation to our banks. Because our banks charge for their services in a very strange way. If you are someone like me who seems unable to keep their current account in credit, you pay a lot of money, because the moment your account overdraws in the UK, you pay unauthorized overdraft fees. And they are very large. Relatively, they are large. If you keep your account in credit, then generally speaking, you get free banking. So the banking model is that those who cannot keep their accounts in credit, like myself, pay for the banking of the rest of the country. Now, that got challenged in 2009. The unauthorized overdrafts charges were challenged. Now, the penalty jurisdiction wasn't actually discussed, and it wasn't discussed simply because it was the background to the case. But in litigation that probably affected every household in the UK, it was noted that the banks had drafted their contracts with their customers so carefully that the unauthorized overdraft was never a breach of contract. So the fee that was payable on taking out the unauthorized overdraft never got to be considered as a penalty, because those contracts were drafted such that it was always treated as an implied request. I issue a check for more money, or I make a payment for more money than was in my account. That is treated under my contract with the bank as an implied request for an unauthorized overdraft. And a fee is payable for that.
Yeah.
And so I suppose my final sentence was just this point, that you've got to decide, do you want fairness in your banking system, or do you want certainty? We went for certainty over fairness, in my view. Sorry, yes.
Yeah, absolutely right, sir. Sir, one last question from our faculty, Professor Yash Pandey. This is from consumer point of view with respect to the contract law. Are such penalty clauses in standard form of contracts enforceable in particular cases of Uber and Ola companies which are having driving business? So when they impose penalties on consumers, it's very difficult for them to take this action to recover the penalties back if they are not at fault. So they have to call many a times on customer care. So ultimately they are suffering a lot. So what kind of this policy issues are involved in it, and how they could be addressed?
Okay, thank you. Well, that's another very good question. when you look at how that case came before Cavendish, came before the Supreme Court, with those two conjoined appeals, one of the biggest contracts you can imagine, one this very small one. One thing I thought was this being set up to allow our Supreme Court to say, we're going to have one set of principles for consumer contracts where there's a disparity in economic bargaining power, and another set of principles for the big commercial contracts. Now, they declined that invitation. They decided we're not going to draw a line down the middle and say one penalty regime for consumers, one for big businesses, and they said we're just having one set of principles. And one of the justifications that came out for that is they said, look, if you're going to protect consumers, you should be doing that by legislation. And don't expect the courts to be able to craft that kind of protection, because that shouldn't be in relation to just one type of contract clause, like a penalty clause. You should be doing that across the full field of contract clauses. And we do have such protections, and we do have protections for unfair contract terms, and they build upon the situation where it's a consumer business contract only, and they look at all clauses. They don't take out penalty clauses as justifying separate treatment. However, of course, a lot of that law in the UK, our consumer protection, derived ultimately from European law. Now, post-Brexit, we are keeping it for the moment, but how much, whether that is going to be developed or whether that is going to be changed, is something we have to see. Some of it will depend upon how much of it we are committed to keeping as the terms of our post-Brexit agreement with the EU. And we are committed to a certain amount of it in terms of product safety law, etc. So yes, there is, consumers are deserving of more protection. There is a machinery to protect them as a class, but it applies more generally than just penalty clauses. And it is an area where I think we'll see some developments soon. So yes, thank you for that question.
Yeah. With your permission, I would like to give one last question from students. So they want to ask that while drafting this clause on liquidated damages, what we should bear in our mind. For example, we have goods and service tax in India. So do we also need to bear in our mind that the taxation law would also be applicable while calculating the damages?
Well, taxation is of course a pervasive topic, isn't it? I mean, it's utterly pervasive and is taught in that way in all our professional exams. I mean, at a general level, I can't say anything, but the tax implications of every contract clause have to be considered. But thinking more generally, what do you think about? Well, the first thing you probably need to do is to buy a copy of this, really, and really to look at the drafting pages at the back. However, to summarize in 2 or 3 sentences, what I think you should do is, if you're acting for a client and you want the clause enforced, then first of all, you want to try to ensure that the event upon which the payment is to be made is a non-breach event. That's your best way of getting out of the penalty jurisdiction. But your second line of defense is that if the court somehow interprets your clause as applying only to breach events, you want it to be enforceable. My advice to clients is that because the test now says you can only do so where there's a proportionate protection of a legitimate interest, I would state in the contract what the legitimate interest you are seeking to protect is. I would include that in the contract clause. Absolutely put it out there and say what it is you're protecting, and use a formula that somehow slides so that the amount you are going to pay, you are requiring to be paid, is proportionate to the damage you're likely to receive. So they're my three guidances, really. Make the payment applicable on a non-breach event. Secondly, state the legitimate interest you're seeking to protect. And third, use a formula that produces a sliding level of payment to make it explicit that you've acknowledged the requirement that the protection has to be proportionate to the invasion of your legitimate interest.
Thank you, Professor Halson. This was such an enlightening session, and you shared valuable information not only for the faculties but students and for everyone. And I hope that all participants has gained a lot from your session. With this, I would request our student Asutosh V, student of BCom LLB honors, to deliver vote of thanks.
That's very kind, thank you.
Am I audible, sir?
Yes, you are, I can hear you, thank you.
Sure, thank you. Good afternoon, one and all. We at the Institute of Law, Nirma University, are indeed honored to have with us, amongst us, Professor Dr. Roger Halson, Professor of Contract and Commercial Law at School of Law, University of Leeds. I would like to extend my humble gratitude on behalf of the students of Institute of Law, Nirma University, for kindly accepting this invitation and delivering such an insightful lecture. I am sure that this lecture has been an enriching experience for all of us, and it will definitely help us in developing a better understanding between the old law and new law of penalty clauses and liquidated damages. Further, I would like to thank our Dean, Professor Dr. Purvi Pokhriyal, for the conception of the International Teaching Month, and thereby giving us the exposure to integrate international vision to our academics and further have a platform for discourse, dialogue, discussion, knowledge, and information sharing. Finally, I would like to thank Professor Amit Kashyap, Nilsa, and the entire organizing team who ensured a smooth conduct of this session and made it a successful event. Thank you.
Well, that is very, very kind. I just want to say one final thank you of my own, if I may. Thank you all for your excellent questions. Thank you very much for listening so patiently. For the faculty, I would be fascinated to learn anything you could tell me about liquidated damages in India. And my very, very final comment really is just, we live in such mad, mad times. You know, please do all look after yourselves and stay safe. And I'm going to finish with the words of the greatest football anthem in the world. You must remember, you'll never walk alone. So please stay safe. Thank you.
Professor Roger. Thank you. And thank you, Professor Stephen Barnes, for joining us. You know, I think it's 4 a.m. in the morning there. And thank you for joining us.
Yeah. Oh, thank you, Steve. I did wonder why you had your cup of coffee there, but now I fully understand why you had your cup of coffee.
Please unmute.
Yeah, I'm just liquidating myself, and I was no damaged for it.
Thank you very much. It's very kind.
Thank you so much.
You have a fantastic event here, so I wish you very well. I'll try and drop into some of the sessions later today.
Thank you. Thank you so much.
Thank you.
Thank you all. Thank you, Steve. Thank you.
Bye-bye. Bye all.
Thank you.
So